Good morning and welcome to One Chancery Lane's webinar series. Today we're discussing illegality and in particular the illegality defence in the light of two very recent Supreme Court judgments which were handed down at the end of October, one of which Andrew Warnock, who is my co-speaker today, and me were involved in. I will be talking to you first, giving you a brief history of illegality and the illegality defence, and discussing the recent Supreme Court case of Stoffel and Grondona. Andrew and I appeared on this back in May of this year. I've personally been dealing with this case since its beginning in Bow County Court back in 2008. I represented the claimant both at trial, where we were successful, and the Court of Appeal, where we were successful, and of course was junior counsel to Andrew in the Supreme Court, where we were successful. Andrew will be talking to you about the other illegality case, which was heard around the same time as Stoffel, namely the case of Henderson and Dorset Health Authority. At the end of this presentation, we will host a question and answer session, and we hope to deal with most, if not all, the questions that you raise. As the webinar goes on, you can submit questions and we shall try to answer those as well. And if you've got any, can you please use the Q&A button, which I think is at the top of your screens, to send your questions in, and we'll try and answer those questions at the end of the webinar as well. We've already had a few questions submitted. Some of them are quite interesting. Some of them appear to be attempts at obtaining free advice, but I don't mind that. Forgive me, I've just muted myself. Now, the topics that I'm going to deal with are set out in the slide, hopefully, that's on the screen now. And are in relation to the Stoffel and Grondona case. The first matter is, what is the illegality defence? It's a common law defence which effectively prevents the courts from awarding the claimant with remedies they would otherwise be entitled to because of illegal conduct linked to their claim. And it's been described as a sort of judicial abstention. Over the past 300 or 400 years, the civil courts have been struggling with the question of what to do when the claimant has been involved in illegal activity when they come to the court seeking a remedy. Classic example being the Highwayman case. And judges attempt to set out rules dealing with cases where illegality is raised have been historically complex and confused. This is because of the infinite variety of circumstances in which the issue arises. A hitman who claims for his money after the job is done, or a driver evading the police who crashes and injures himself. Can either of them claim for what is due, what they think is due to them? The illegality may arise in any area of civil law, from contract to tort to property law. What should the court do when faced with illegality by the claimant? Should it grant relief or refuse to assist the claimant? If it refuses to assist the claimant, this may give the defendant, who may be equally culpable or completely negligent, as in this case, that it may give the defendant a windfall victory. And it is a very serious matter to deprive someone of their legal rights. Until Tinsley and Milligan, the test as to whether to grant or refuse relief was the rather vague public conscience test, which was described by Lord Gough in Tinsley as little different to a general discretion. And I'm sure that some judges would have loved that, to have a general discretion as to whether to allow or refuse relief, especially the more censorious ones. And now this public conscience test led to uncertainty, and the House of Lords in Tinsley and Milligan famously introduced the reliance test. If the claimant did not have to rely on their own illegal act to found their claim, then they would succeed. And in Tinsley, the claimant simply had to rely on the presumption of a resulting trust in her favour. But this case was much criticised. The reasoning in Tinsley meant that the outcome of any case would depend upon a procedural or evidential issue rather than the merits of the case itself, and it led to particular problems in cases where the presumption of advancement applied. Now, during a flurry of other recent Supreme Court decisions on this area, it was recognised that there were two competing seams of jurisprudence developing, one based on the reliance test and the other based on policy considerations. And so the case of Patel and Mirza in the Supreme Court was seen as an opportunity for the Supreme Court to inject cohesion into this troubled area. And as we know, the majority in Patel and Mirza, by 6-3, it was a 9-judge panel, overruled the reliance test in Tinsley and confirmed the public policy analysis and range of factors approach of Lord Toulson as being the appropriate test of whether the illegality defence should apply in a case. Lord Toulson described the two broad policy reasons for the doctrine of illegality as preventing profit from the illegality and ensuring coherence and harmony in the law. Preventing the law from giving with one hand whilst taking away with the other. And you'll see on the screen the trio of considerations test at the bottom of the slide, set out by Lord Toulson to guide judges on how they should approach the illegality defence when it's raised in a case. And it's essentially a structured discretion for judges, and they are to effectively weigh up the various policies at play and whether it's disproportionate to deny the claim. There were various problems with Patel and Mirza. Would it lead to more uncertainty? Allow judges too much discretion? Did it seek to widen or narrow the illegality defence? Would it apply to contractual or negligence claims? Of course, Patel and Mirza applied to a restitutionary claim. And at what part of the proceedings would a Patel and Mirza inquiry be engaged? And from my own personal point of view, an important question, how would it prevent opportunists and virtue signallers from raising illegality as a defence? Now, Stoffel and Grondona was a chance for the Supreme Court to refine the guidance in Patel and Mirza, perhaps to try and deal with some of those questions raised, and apply the test in the context of professional negligence claims against solicitors. In Stoffel and Grondona, the solicitors, the appellants, admitted negligence in the purchase of a property that they had been instructed in that they failed to register Miss Grondona's transfer ownership with the land registry. They had, that's the TR1. They had failed to register her lender's charge and had failed to discharge the charge of the previous lender. It also transpired in the course of the proceedings that the solicitors had acted for the seller as well in the very same conveyance. So they were acting for the seller, Miss Grondona, the purchaser, and for Miss Grondona's mortgagee. And indeed, in Bow County Court, I distinctly remember my opponent rhetorically asking at an early stage, what was wrong with that? And and troublingly, I also remember the judge actually agreeing with him. But leaving that aside, one of the consequences of the above failures to register Miss Grondona's ownership, the lender's charge, and to discharge the previous charge, one of the consequences, of course, was that the property was repossessed by the existing lender, the seller's lender, and so the claimant lost her property. The solicitor defended the claim for damages on various bases, but of course the one that ran all the way to the Supreme Court was the illegality defence. And he alleged that the claimant had obtained her mortgage by fraud, in that she lied to her mortgage company, failing to tell them that she and the seller were known to each other, that the seller was to remain the real owner of the property despite the transfer of legal ownership to her, and that the balance of the purchase price was from the seller himself. So effectively the conveyance was for the seller's benefit, not for hers, and something that she did not disclose to her mortgage company. This was a mortgage fraud. The solicitor's legal team argued that the transfer was a sham, so the property transferred to her was a sham, to create a transaction which would attract high street lending for the benefit of the seller. The claimant was, Miss Grondona, was described as a cat's paw in a phantom purchase. At first instance, the trial judge, who found that the transfer was a sham and found that the mortgage agreement was also a sham, as it was procured by fraud, nevertheless upheld Miss Grondona's claim, as she found that by Tinsley and Milligan, the claimant did not rely on her illegal conduct for a claim for damages for negligence. These were considered by the trial judge as conceptually entirely separate from the mortgage fraud. And this was in early 2016. Shortly thereafter, the judgment in Patel and Mirza was handed down, overruling the reliance test in Tinsley. Permission to appeal was given to the solicitor, and of course he leapt at the chance to appeal, perhaps thinking that Patel and Mirza widened the illegality defence. Needless to say, in the Court of Appeal, the appeal was dismissed. The Court of Appeal held that the transaction itself was not a sham. The transfer was not a sham. So they overturned the judge's finding on that, finding that the transfer of legal ownership to Miss Grondona was the very essence of the arrangement. And then applying Patel and Mirza, the Court of Appeal found that allowing the claim would not enhance the policy against mortgage fraud, and that denying the claim would be against other policies, and we'll come to those in a moment when we deal with the Supreme Court decision. And they also found that to deny the claim would be disproportionate. In the Supreme Court, they too, the Supreme Court, by unanimously, they too dismissed the appeal. The leading speech was given by Lord Lloyd Jones, the Supreme Court considered the following questions. Firstly, what was the purpose of the policy against mortgage fraud? Secondly, would that purpose be enhanced by denying Miss Grondona's claim? Thirdly, what other policies were at play and would be affected by denial of the claim? And lastly, whether it would be disproportionate to deny the claim. Now, in dealing with those questions, in arguments, the appellant's lawyers argued that the purpose of the prohibition was to support or bolster the criminal law. And they argued that denying the claim would deter fraud, that it would supplement an inadequate criminal law, where they argued that obtaining prosecutions for mortgage fraud was notoriously difficult. No evidence was adduced on that point by them. That denying the claimant's claim in a civil court would be appropriate, as it would be a punishment that properly fits the crime, they argued. And this raised a number of concerns with the Supreme Court, namely, why should the civil law be used to shore up deficiencies in the criminal law? And are punishment and deterrence matters for the civil law? Would a fraudster be deterred from committing a mortgage fraud if he knew that he wouldn't be able to sue his solicitor in the unlikely event that the solicitor was so utterly negligent as to cock up the most basic of registration requirements? Well, of course he wouldn't. And these were rather bizarre arguments raised before the court, with the greatest, of course, with the greatest respect to the appellant's legal team. We argued for the respondent that the purpose of the prohibition against mortgage fraud was to protect the mortgagee. By doing so, this would protect the public at large, of course. And this was favourably received by Lord Lloyd Jones. The question being, would denying the claim protect the mortgagee? The answer was a resounding no. Why would it? How would it protect the mortgagee? Furthermore, denying the claim would adversely affect the mortgagee, and this was found, and this argument found favourable with Lord Lloyd Jones as well, that denying the claim would adversely affect the mortgagee in that their security would be undermined. The respondent, Miss Grondona, if her claim were denied, would not be able to claim the value of the loss of the property so as to pay off her debt to the mortgagee. The whole action started because the mortgagee, finding that they did not have a registered security, sued Miss Grondona as for an unsecured debt, effectively. Miss Grondona then had to add the solicitor as a Part 20 defendant in the action. So effectively, the mortgagee would be rendered to the status, as they were, of an unsecured creditor, which of course defeats the whole object of having a legal charge against someone's property for security. The Supreme Court then considered the other policies that would be adversely affected by denying the claim. And this is the second stage in the tree of considerations of Lord Salson. And those other policies were threefold. Firstly, the denial of the claim would run counter to the policy that solicitors should do their jobs properly and not negligently. They should be alert to irregularity from the start, not simply take the client's money, carry out a very poor job or a negligent job, and then complain about some illegality later when they're trying to avoid a negligence claim. The second policy that would be adversely affected by denial of the claim was that clients should be able to recover their losses from negligent solicitors through their indemnity insurance. And this is the importance of professional indemnity insurance. It is there to compensate for this type or any negligence. The third point was slightly more, the third policy that was adversely affected by denial of the claim was slightly tangential and more of a property law point, in that property, it was recognised, would pass even under an unlawful contract. The transfer in this case from the seller to Miss Grondona had been complete, and denying the claim for damages for loss of that property would undermine the very principle of property ownership. All of this policy balancing was clearly in favour of Miss Grondona. According to Lord Lloyd-Jones, that was enough to find for her. Policy considerations, he decided, needed only to be considered only on a high level of generality, and if they were found in favour of the claimant, the Patel and Mirza inquiry, the illegality inquiry, ends there. There was no need to consider the third stage of proportionality. However, nevertheless, he went on to consider proportionality and found that amongst the various considerations, such as seriousness or centrality or relative culpability of the parties, and the other more granular aspects of the case that one would need to look at to assess proportionality, the Supreme Court found that centrality in this case was the real issue. And it was quite clear that the fraud, lying to the mortgage company, was not in any way central to Miss Grondona's claim, and it was quite distinct from it for her claim for negligence. Despite the appellant arguing that the instruction of the solicitor was essential for the fraud to have occurred, the fraud was actually committed before the solicitor was even instructed, i.e. she had made her mortgage application with the various representations that she made, and the money was drawn down. Indeed, the fraud took place not because of the solicitor's instruction, but in spite of their negligent performance of it. And that clearly showed that it was unconnected, it was not central. So even if the policy balancing was against us, then had the court decided whether it was disproportionate to deny the claim, that would have been in favour of Miss Grondona as well. The final point of Stoffel is that Lord Lloyd-Jones favourably considered the respondent's argument, our argument, that the reliance test was still relevant, the reliance test that was overruled in Tinsley, in Patel from Tinsley, was still relevant as regards the issue of centrality. If the illegality is not relied on, then it's unlikely to be central. So this is potentially a revival of the test in Tinsley. And indeed, Lord Sumption in his dissenting speech in Patel made the point that the reliance test was the narrowest test available. And if the claimant gets past that, then their claim is very unlikely, highly unlikely, to be harmful to the integrity of the legal system. So after Stoffel, where does that leave us? Patel and Mirza is still very much the abiding case in relation to illegality. There are still problems, I would suggest. The illegality defence has not been tamed, as I put in the slide, save for a few rare and important exceptions. and Andrew will be dealing with one of those in a moment from Henderson, my personal view is that the illegality defence remains troublesome. It is, by and large, the domain for virtue signallers and chancers, and even worse, for chancers pretending to be virtue signallers. There is still mileage in raising this defence for those chancers and virtue signallers, as it may work to stifle a claim at an interlocutory level. During the interlocutory stages of Grondona, because of the loud hectoring allegations of fraud, which were made at every hearing before every district judge and at every application, the claimant was given no indulgence by the court of any kind, even to the extent that she was one day late with her reply to their amended defence and was not given permission to rely on it. It was as if the illegality defence, despite being found to be utterly irrelevant at the end of the day by the Supreme Court, had already inflicted its insidious effect during the currency of the proceedings. This almost caused the wheels to come off her case a number of times. Another continuing problem with illegality is that if the defence is raised, the case still has to go the distance for it to be decided. It's still an issue for the trial. And the danger with that is shown again in Stoffel and Grondona, where the claimant was put to a 6-day trial on this issue alone, really, and 2 levels of appeal, of course, all the way to the Supreme Court, on this issue, which, of course, the Supreme Court decided should not have been raised in the first place. And it was irrelevant to the otherwise admitted negligence of the solicitor. The matter should not have gone to trial in the first place. The only reason that it did is the illegality that was eventually found to be irrelevant. So really, just to finish off, for justice to prevail in relation to the illegality defence, an early filtering system is needed to prevent the sort of opportunism at play here. Lord Lloyd-Jones, in his speech, proposed, of course, that the policy balance at a high level of generality should be the first step as a sort of an early method of deciding whether the defence is good or not in a case. And if in the claimant's favour, the court needn't go any further to consider proportionality. However, there is a problem with that in that judicial decisions based on high levels of generality mean more appeals. Opportunistic defendants who want to evade their professional liabilities can still run with this defence. Perhaps the best way forward would be to have an early inquiry as to whether the illegality is actually central to the claim, or indeed whether it is relied on. So to use the Tinsley Reliance test as an early filtering system, as of course, as I've already said, Lord Sumption described it as the narrowest test available, and if the claimant gets past this, then it's highly unlikely their claim would be harmful to the integrity of the legal system. So perhaps, I hope, there might be a revival of the Tinsley Reliance test, and that could be just around the corner. That's my presentation on Stoffel and Grondona. Thank you for listening. I hope it hasn't been too dry. Next, Andrew Warnock will be presenting his webinar on the Henderson and Dorset Health Authority case. Thank you.
Thank you, Maurice. Good morning, everybody. In her 20s, Michaela Henderson developed problems with her mental health. She was diagnosed with paranoid schizophrenia or schizoaffective disorder. For over 2 years, she had been hospitalized under the Mental Health Act. In August 2020, she was living in the community in supported accommodation, but her psychiatric condition began to relapse. She missed appointments. A support worker was very concerned about her. The mental health team, however, decided to wait and assess her when her previous care coordinator would be available. The assessment was due to take place on the 25th of August. That day, her mother came round, concerned about the fact that she hadn't heard from Akila for a number of days and hadn't been able to get hold of her. She went down the garden. Akila came out with a kitchen knife and stabbed her 22 times. She was in a florid psychiatric episode at the time of the killing. She was charged with murder. The prosecution accepted a plea of manslaughter by reason of diminished responsibility in the light of the psychiatric evidence. The judge sentenced her to a hospital order under Section 36 of the Mental Health Act and an unlimited restriction order under Section 41. This meant that she would go to hospital and that she could only be released eventually when a court would decide it was unsuitable for her to be released along with doctors. In sentencing remarks, the judge described it as a desperately sad and tragic case and said that it was clear that Akila had little, if any, true control over what she had done. And he said she should not be seen as bearing a significant degree of responsibility for it. Ms. Henderson brought a claim against the Dorset Health Care University Trust, which had responsibility for her, the mental health team. She claimed damages for loss of liberty, psychiatric injury caused to her by the killing, general damages for loss of immunity by reason of the fact that she was in hospital, a share in her mother's estate, which she was not able to inherit because of the operation of the Forfeiture Act 1982, which applies when someone has killed when a beneficiary has killed the testator, and the cost of psychotherapy and the cost of a care manager. The trust admitted negligence in having failed to return her to hospital on the basis of her manifest psychotic state. The killing would not have occurred had that been done. All the ingredients of a cause of action were there. However, the trust argued that the various heads of loss were irrecoverable by reason of the illegality principle. And on the face of it, the trust had clear and consistent precedent on its side. Most importantly, the decision of the House of Lords in Grey and Thames trains, which is on the next slide. In that case, the claimant was a passenger caught up in the rail crash at Ladbroke Grove in 1999. He suffered post-traumatic stress disorder. While suffering that condition, he killed a man. He too was convicted of manslaughter due to diminished responsibility and was ordered to be detained in a hospital under Section 47 and Section 41 of the Mental Health Act. He too sued, and the defendants admitted negligence, but argued that the doctrine of ex taupi causa barred his claim. He claimed damages for the direct consequences of his detention, general damages for it, and loss of earnings. Those were known as the narrow claim because they resulted from his sentence, and damages for the wider consequences of the killing, his feelings of guilt, and also an indemnity against any claim brought against him by dependents of the deceased. This was the wider claim. The House of Lords held that both the narrow and wider claims were barred. Lord Hoffman summarised You cannot recover loss where you have suffered the consequence of your own criminal act. In relation to the narrow claim, Lord Hoffman ruled and their lordships agreed, it would be inconsistent for the criminal law on the one hand to take away your liberty, and for the civil law on the other hand to say you should have compensation for that. Nor could Mr. Gray recover for the wider losses he claimed, the guilt and so forth, because it would be contrary to public notions of the fair distribution of resources that a claimant should be compensated for the consequences of his or her own criminal conduct. Further, the House of Lords held the wider rule applied where it could be said as a matter of causation that if the immediate cause of damage was the claimant's intentional criminal conduct, then it was caused by it, even if that conduct would not have occurred but for the defendant's earlier negligence. Unsurprisingly, following Gray and Thames Trains, the High Court judge and the Court of Appeal struck out Ms. Henderson's claims. The Supreme Court gave her permission to appeal. The first question which arose was, could Gray's case be distinguished? The argument made on behalf of Ms. Henderson was that Gray did not apply where, as in her case, the appellant had no significant responsibility for the killing. That argument was rejected. The crucial point was not the level of the appellant's responsibility, but the fact that she had been found criminally responsible at all. Gray, the Supreme Court pointed out, involved the same offence, the same sentence, and the reasoning applied whatever the level of personal responsibility. Since Gray could not be distinguished, did it remain good law? Could Gray stand in the light of Patel? Which is the next slide. And this raised an important point of precedent. Did Patel and Mirza, which concerned a case of unjust enrichment, apply in this area of law concerning personal injury and clinical negligence? That was one question. And if it did Patel and Mirza mean essentially a free-for-all, where past cases are considered afresh and decisions reached by a balancing exercise in the individual case? Well, the Supreme Court answered the questions as follows. Firstly, Patel and Mirza does apply across the common law, although Patel and Mirza itself involved a case of unjust enrichment. It applies to cases involving tort law, contract law, and property law. But, and this is an important point, I think, from the decisions both in Henderson and Stoffel, Patel and Mirza was not year zero, as Lord Lloyd Jones put it. Decisions which were made before Patel remain of precedent value and they remain binding unless it can be shown that they cannot stand with the reasoning of Patel. And the Supreme Court held, viewed from that light, Gray was not inconsistent with the approach in Patel. Indeed, on the contrary, Gray essentially conducted the policy analysis which Patel envisaged. Gray showed how Patel played out in this type of case. And the Supreme Court identified, firstly, that the fundamental policy which underlay the decision in Gray was the need for consistency to maintain the integrity of the legal system. And that was the very matter which Patel had said was the underlying policy consideration in illegality cases, coherence and consistency in the law. The Supreme Court held that Ms. Henderson's argument that there was no inconsistency where she had no significant personal responsibility. Remember, that's what the judge who sentenced her had said for the criminal act. That argument was rejected. Responsibility for her criminal act was diminished, but not removed. And Lord Hamblin, who gave the judgment, pointed out it was not an insanity case. Inconsistency, he said, would arise if the law treated conduct as criminal on the one hand and accepted that the same conduct gave rise to a right of contribution on the other. The criminal under the criminal law becomes the victim under the tort law if that approach is taken, and that is incoherent. The law would be condoning when facing right, but it condemned when facing left. And finally, the court rejected an argument that there was insufficient turpitude to even engage the illegality defence in Miss Henderson's case. Again, argued on that basis because of her lack of significant personal responsibility. The court held that one had to look at the nature of the offence. And there might be exceptional cases, they said, where conviction for a criminal act would not constitute turpitude. And they gave the example of trivial cases in cases of strict liability. And it was possible in cases like that, the doctrine would not apply. But it couldn't be said it didn't apply to a case of manslaughter. So the court then adopted looking at the Patel analysis to look at the policies in favour of denying liability. And the policies for denying the claim included, as we've just discussed, consistency between the criminal law and the civil law. A second policy, which was identified, was public confidence. Could the public have confidence in the legal system if, on the one hand, somebody is convicted of criminal offence, and on the other hand, they're awarded compensation for it? And finally, deterrence. Now, the court recognised that it was probably unlikely the thought of going to jail would have affected the actions of Miss Henderson herself, who was in the middle of a florid psychotic episode when she killed her mother. But they said you had to look at the matter more broadly than the individual case. And they felt there might well be cases where there was a deterrent effect in a clear rule that unlawful killing never pays. Did any countervailing policies outweigh this? Well, the court considered a number raised by Miss Henderson. Firstly, she argued it might improve standards in the NHS if they had to pay for their negligence. Well, the court rejected that. They thought it was unlikely it would make much difference to the approach of NHS bodies. And that's just on the next slide. It was doubtful if there was a policy of providing compensation to victims who are not significantly responsible for their actions, which was the other point raised by the Ms. Henderson. The Supreme Court doubted there was such a policy. And they thought that the next argument, that there was a policy against public bodies, or policy in favour of public bodies having to pay compensation to those they injured, really begged the question as to whether there was such a policy and as to whether that was a consideration. And finally, policies of ensuring defendants in criminal trials received sentences proportionate to their offending. They felt that policy wasn't offended because Ms. Henderson had been convicted of manslaughter. And there was no question of her receiving a disproportionate sentence simply because the civil courts denied her claim. That said, the Supreme Court recognised that there was some force in some of these 4 points made by or on behalf of Ms. Henderson. But the court said that they came nowhere near of sufficient weight to outweigh those in favour of denying the claim. And in particular, to outweigh the policy in favour of consistency and coherence across the law. So, having decided that the policies lay against Miss Henderson's claim, the Supreme Court needed to consider proportionality. Was it proportionate to deny it? And the court held, well, the conduct was serious, it was central to the claim, and it was an intentional crime, even if the ultimate conviction was by reason of diminished manslaughter, by reason of diminished responsibility, whereas by contrast, the trust had merely been negligent. And having regard to these factors, the Supreme Court held it would not be disproportionate to bar the claim. Now, Henderson is quite helpful, particularly when read with Grondona, I think, in giving some explanations and clarifications of the Patel and Mirza test and what Patel and Mirza means. And the first point is it is clarified that Patel and Mirza was not a legal revolution. This is quite an important point. Some have interpreted Patel as essentially allowing a discretionary approach to illegality in particular cases. Indeed, it was a concern of the minority in Patel and Mirza that that might be what the new Patel and Mirza test would lead to. However, the Supreme Court have sent a strong message that that is wrong. And I think it's particularly noteworthy that the results of both the Stoffel case and the Henderson case would have been the same under the pre-Patel law. Ms. Grondona would have won, as indeed she did win at first instance, on an application of Tinsley and Milligan, and Ms. Henderson would have lost under an application of Gray and Thames trains. And both outcomes have resulted in the recent Supreme Court rulings. Patel and Mirza, it seems to me, has not significantly widened the illegality defence, and these two cases demonstrate that as well. If anything, it's probably narrowed it. There may be cases where it would be disproportionate to disallow a claim which would otherwise be barred, and cases which previously failed because of illegality, and in particular cases involving the presumption of advancement of property law, cases where under the old Tinsley and Milligan rule, claimants had to rely on their illegality and point out why a transaction had been made, because otherwise a presumption of advancement would have presumed that they'd made a gift. Those cases which would previously have failed under Tinsley and Milligan would now succeed. So if anything, Patel and Mirza, I think, has resulted in a slight narrowing of the circumstances in which the illegality defence will succeed. The next point which the Grondona and Stoffel and the Henderson and Dorset cases help with is how one approaches the policy considerations. And the Supreme Court have said that evidence will not be admitted on these. The policies in favour of or allowing or denying a claim are to be considered at a high level of generality, looking at the underlying policies of the law, policies which can be distilled in many cases from the old case law. Thirdly, particular weight is to be given to the considerations that a person should not be allowed to profit from their wrongdoing and that the law should be coherent. These two factors are the most important, but particularly perhaps that relating to coherence. And fourthly, the Supreme Court has clarified that you do not need to go on to consider the question of proportionality if, on a balancing of the policy considerations, the claim should be allowed. The proportionality test is really a misnomer In reality, it's actually a disproportionality test. If policy points in favor of disallowing a claim, then a claimant might still win on proportionality. And fifthly, a big point to take away from the decisions, in my view, is the importance of centrality. Centrality was highlighted in both cases, both at the proportionality stage, but even more significantly, at the policy weighing stage. Lord Hamblin especially said at paragraph 120 in the Henderson case that in considering the consistency and coherence of the law, the closeness of the connection between the claim and the illegal act may well be of relevance. The closer that connection is, the greater and more obvious may be the inconsistency. And if one looks at the facts of each of the cases, the killing was central to Miss Henderson's claim. It was all about the killing. It was all about the consequences of the killing, how that had affected her and what she'd lost because of it. By contrast, the fraud, although it was a mortgage fraud, was really part of the background to Miss Grondona's claim, because as Maurice has already explained, by the time the solicitors were negligent, not only had the misrepresentations, the fraudulent misrepresentations been made to the mortgagee, but the mortgage advance had already been made. So why then did Miss Grondona succeed and Miss Henderson fail? And it seems to me there are a number of central reasons to draw out from this. Firstly, as I've mentioned, precedent and the old law. The same results would have been reached in both. Perhaps that's not so much a reason, but it's certainly a context in which the claims have to be seen. Secondly, coherence. Miss Henderson was suing for what the criminal justice system had condemned as a criminal act. Her claim arose out of that very act, the killing, and it would be incoherent for the law to face both ways. By contrast, Ms. Grondona had an argument, and one that the Supreme Court considered a strong argument, that coherence went the other way. And that was, as Maurice has mentioned, that the law recognises that property may transfer under an illegal transaction. Indeed, it usually does transfer under an illegal action, contract. And if the law recognises that property transfers under such a contract, it would actually be incoherent and inconsistent for the law to say, well, we recognise you've got those property rights, but you can't sue your solicitor for losing them on you. Another reason that distinguished the cases, and it may well be that this is a reason which might apply in other cases too, was preserving assets for innocent victims. It may well be that in cases involving the loss of assets, particularly where they provide security, there is a policy that may weigh against denying the claim. As Maurice has pointed out, it was actually in the mortgagee's interests in Grondona's case that the title should have been registered so that they could then get their charge registered against it. But finally, and I think this is perhaps really the crucial difference between the two cases, is the issue of centrality. I think this is really the biggie that underlies the difference between the two decisions. Perhaps the cases could be boiled down to this very essence, because if illegality is not central to a claim, it's difficult to see how allowing the claim could be inconsistent with that illegality, and vice versa. As I've said, Ms. Grondona's fraud was already over by the time the solicitor was negligent. The money had been pocketed. By contrast, Ms. Henderson's claim was all about the killing. And other policy factors may be influenced by that centrality factor. For instance, the point of deterrence. the Supreme Court considered deterrence did not assist the solicitors in Ms. Grondona's case, but in Ms. Henderson's case, they considered that was a significant factor. It may be centrality goes some way to explaining the difference. And that then brings us back to what Maurice was mentioning a few minutes ago, the question of how do we judge centrality? And that's on the next slide. Here, I think we do see the rehabilitation of reliance. An important factor in judging centrality is whether the tortfeasor has to rely on the illegality to advance their case. And as Maurice said, this was a point which we made in the Supreme Court and which found favour in Grondona. And in the Henderson case, the Supreme Court expressly recognised this in their judgment, where they said that the rejection by the majority in Patel as the test of illegality did not mean that reliance was thereby rendered irrelevant to the policy-based approach. It may not provide a satisfactory test of illegality, but it will often be a relevant factor. In other words, as Maurice has said, Tinsley and Milligan lives on. To borrow from our French friends, the more things change, the more they stay the same.
Yes, thank you, Andrew. Well, we're almost finished. There are a few questions that have been sent in. There is one, quite a good one actually. Can we deal with that? Should we? I'll read it out and see if we can offer up some answers. An executor is alleged by a beneficiary to have mishandled assets in an estate for his own benefit. This is denied. Based on evidence, the executor alleges that the will appointing him was forged by the beneficiary, thus that he should never have been appointed by the courts as executor, and that the beneficiary has hidden substantial assets overseas to evade inheritance tax. Is there an illegality defence for the executor? Well, well, that description perhaps is replete with questions to ask, but just looking at it on a policy balancing level, would denying the claim of the beneficiary against the executor further the purpose underlying tax evasion, underlying the law against tax evasion? Probably not. The other policies at play there would be that the court is obliged to protect the estate, and that executors must do their jobs properly. And of course, if the executor is alleged by a beneficiary to have mishandled assets in an estate for his own benefit, then clearly those policies are in favour of the beneficiary's claim against the executor.
I tend to agree. Well, I also wonder if centrality isn't a factor as well there, particularly when you're looking at evasion of taxes.
Yeah, yeah. So is there an illegality defence for the executor? Unfortunately not, and it's probably one of those cases that I would describe as being a bit of a chancer. Have we got any other questions? I can't see any on the Q&A. That may be because I'm not reading the right place, but no, I can't see any more. Forgive me if I've missed yours, anyone. But no, I can't see any. Thank you for attending and listening to our presentation, and I hope it's been informative. And thank you, Andrew, and I'll hopefully see you soon.
Yes, and you can find more information. We have lots of articles on our website and on all sorts of subjects. And also you can follow Chancery Lane on Twitter as well, and you'll find all the details on the website. Thank you very much.
Bye-bye.